Horrifying precedent: court rules cops can allow dogs to maul innocent people. A disturbing and reckless precedent was just set by the U.S. Court of Appeals for the Fourth Circuit, which held that the U.S. Constitution does not necessarily require cops to stop a canine from tearing an innocent person to shreds. Seriously. According to the ruling in the case of an innocent homeless man being mauled nearly to death by a canine, police officers who deliberately allow their canine to maul innocent people will be immune from liability and victims will have zero recourse. As Slate reports, the grisly facts of the case are uncontested. One night in 2010, Officer Terrence Garrison and his police dog, Beagle, were tracking a robbery suspect in High Point, North Carolina. Beagle led Garrison to an abandoned house, then attacked a man crouched behind a bush near the front stoop. Garrison quickly realized that the man did not match the physical description of the suspect. In fact, he was Christopher Manny, a homeless man accused of no crime. But Garrison decided that the man might still be dangerous, so he demanded that Manny show his hands before calling off Beagle. But Manny was using his hands to try to protect himself against the dog and pleaded with Garrison to stop Beagle's attack, insisting that he had done nothing wrong. After allowing the mauling to continue for 10 seconds, Garrison finally told Beagle to stop. He then put Manny in handcuffs and called medical support. Because Garrison allowed his canine to continue mauling Manny, the innocent homeless man suffered severe injuries. By the time he was brought to the hospital, Manny was in critical condition. Beagle had torn apart the top of Manny's head, removing an entire 2-square-inch section of hair, skin, and tissue which would later require a 16-inch skin graft. The dog also bit Manny's arms and legs so severely that it led to a brachial artery blood clot with massive blood loss, bruising, and swelling. After making a long and painful recovery, Manny attempted to hold the officer accountable for his sadistic and torturous act. He then sued Garrison for violating his Fourth Amendment right to be free from unreasonable seizures. As it stands, a dog bite qualifies as a seizure under the Fourth Amendment. So, Manny argued that the time Garrison allowed the canine to rip him apart was unreasonable. However, the U.S. Court of Appeals for the Fourth Circuit did not agree. Insanely enough, the court concluded that Garrison was shielded from liability because he did not violate a clearly established constitutional right. According to the majority, as Slate reports, Fourth Amendment precedents do not unambiguously prohibit officers from prolonging a dog bite seizure until a subject complies with orders to surrender. The majority analogized the mauling to a Terry stop, during which an officer may briefly stop and frisk individuals on the basis of reasonable suspicion. Garrison, the majority concluded, had really just engaged in a type of Terry stop in which the classic Terry tableau is replaced by something more dynamic. Simply put, the court ruled that Garrison's use of his canine to maul a man nearly to death was reasonable because it is no different than a stop and frisk. Image, http://pixel.watch/qt7. Judge Pamela Harris, the only judge with enough humanity left in her to dissent, explained why this ruling is nonsensical and disturbing. Manny was not himself suspected of any crime, armed or not, and he did not attempt to flee or to resist. Nevertheless, Officer Garrison deliberately subjected him to a canine attack in order to rule out any possibility that he might pose a threat. Whether or not a more customary Terry stop might have been authorized, I think it is clear enough that the circumstances did not justify the sustained mauling of Manny. Clear enough, that is, to warrant denial of qualified immunity to Garrison on Manny's excessive force claim. Harris noted that justifying the mauling by comparing it to a Terry stop was particularly ludicrous because there was not reasonable suspicion sufficient to support a Terry stop in the first place. He, Garrison, was aware that there was a perfectly innocent explanation for Manny's presence near the abandoned house. And I would not count against Manny his failure to stand and identify himself, which Manny quite reasonably, in hindsight, attributes to his fear that a sudden movement might prompt a dog attack. Citizens are under no freestanding obligation to identify themselves to the police. While Harris disagreed, the rest of the court believed Garrison intentionally prolonging a violent assault on Manny to determine whether he might pose a threat, is entirely just. It is likely that Manny will appeal this ruling. However, the mere fact that a court would rule in such a manner illustrates a much larger problem in America. Because Americans support a system that continuously refuses to hold police accountable while simultaneously granting them special privileges, cops can quite literally get away with murder.